All right. So welcome, everyone. I want to introduce Deb and John from Maddin Hauser, who are going to do our presentation today. If you have any questions, go ahead and put them in the chat box, or it's going to, like they said, we'll say it's going to be more of a conversation. So please feel free to ask all your questions, and I will hand it over to Deb and John.
Good afternoon, everybody. Thank you for taking the time here today. As Amanda mentioned, my name is John McKenzie. I'm a shareholder with Maddin Hauser law firm located in Southfield. We're a full service law firm with all your core practice areas. You might wonder why I'm in front of you today. And one is because I love the boating industry. I was born and raised on Lake St. Clair, where I still live today, and spend most of my free time on the water. And as a result of that, I do a lot of business and work with local marinas and dealerships in that area. So I'm familiar with some of the issues that you all in the industry faces. And with that, I'll let Deb introduce herself.
Hi, everybody. Thanks for the opportunity to let us present today on, I think, timely consumer-based issues, because with the start of the boating season, I always feel open the floodgates of consumer complaints. I do love boating. I'm not as hands-on, I'd say, as much as John. I grew up on the East Coast, access to a lot of friend and family boats, although I'm not a boat owner, but I enjoy a good boat ride as often as possible. And my practice is all litigation, and including probably, I'd say, the last 6, 7, 8 years, a lot of litigation involving representing a boating dealership. So I've seen a ton of consumer complaints in that area, and like we said, it's just, I think, a good time of year to focus on some of these issues and give you our 2 cents.
Okay. All right, so I'm going to do my presentation first. We're going to jump around on the slides a little bit, but I have to indulge for a minute before I go into the substance. I had to include a picture of myself from a few years ago doing a poker run up in Boyne. That's the Boyne Thunder Run, if any of you are familiar with it. That's my old boat that I still love. My wife made me sell it when our daughter came along. But anyway, I never thought I'd get to use it in my legal practice, but here you go. So topics we're going to cover. And we're just going to scratch the surface. None of this is a deep dive, okay? But it's a few highlights and high level bits of information that I deal with my clients or our clients in this industry. One is insurance coverage issues. The other is standard business operations. That's the 2 points I'll hit. But if anybody has any burning desires, I do handle a lot of issues with warranty and recall, various real estate issues that specifically marinas face, and then dealership agreements and some of the things that they, and Deb will kind of touch on the dealership stuff, but if there's any questions, certainly feel free to ask. So insurance coverage, I'll often run into a scenario where a dealer or a marina or some other business in the boating industry doesn't have proper coverage, and it's because they didn't know what coverage they needed. And a lot of times it comes down to the insurance agent that you're working with, or sometimes it comes down to the owner not wanting to pay the premium for enhanced policies. But you may be surprised the amount of times that I see a business in the boating industry, whether it's a dealer or a marina or a storage yard, that just has a general liability policy. And the general liability policy is not going to cover a boating industry operation for the various risks that they face. And what I mean by that is a general liability policy covers only bodily injury or property damage arising out of an occurrence. An occurrence is a fancy word for saying an accident. But what you have to watch for is the traps, the exclusions in the policy. And 2 of the main ones that I see that cause a loss of coverage to the boating industry is, one, the your work exclusion, which means, what that means is if a marina, which most of them have service repair shops and even dealerships, if you're working on a motor or any part of a boat and you damage it while you're working on it, the policy's not going to cover it. So, and it also won't cover anything that's in your care, custody, and control. So anybody's boat that you're storing or working on is not going to be covered. All the general liability policy is going to cover you for is if somebody's walking on your premises and slips and falls, that's a common coverage. Or somebody's got their automobile parked on your property and you hit it with a high-low, it will cover those types of things. But what the marine industry needs for coverage is what's called a marina operators legal liability policy. And that policy covers dealerships, it covers storage yards, it covers marinas, basically anybody that's working with boats. And the coverages that's independent from the difference between the general liability policy is the what's called MOL for short, marina operators legal liability, will cover you if you damage somebody's boat while it's in your care, custody, and control. The general liability policy excludes that. The MOL policy will cover it. It also covers moving boats around the yards, and it covers damage to machinery and equipment on the vessels. So that's really, the key takeaway for insurance is this is the policy that you all should be talking to your agents about to make sure that you have, if you want to have the least amount of exposure. Because what it comes down to, if your customer submits a claim against you or files a lawsuit, this MOL policy is going to provide you, should provide you coverage where your insurance company will pay for the attorney to defend you and also pay for if there's any liability, that judgment or settlement that is entered against you. If you only have the CGL, the commercial general liability, you're likely not going to have coverage for a lot of this stuff, and you're going to be paying for the defense costs of an attorney on your own. So that's a key takeaway. Something else where I see that I'm all about risk management. I attend a lot of events in the summer, poker runs, boat shows, and other events on the water. And I'm a huge proponent for event insurance. You can usually get these through excess and surplus line insurers, which means it's not State Farm, it's not all state. You have to go to what's called excess and surplus insurers because they're special risk policies. But for example, if any of you host a poker run, you should insure that event, and it will cover it. It'll cover liability for anybody that's injured. There's people running boats. There's a lot of times there's alcohol at these events, and those types of policies will cover those risks, where the other two will not. So that's a special event coverage. Now, just to step away from the insurance, I just want to scratch the surface of some business operational issues that I deal with. A lot of marinas have seasonal workers, and they'll come and go during the seasons because marinas work during the boating season, and then they're basically just storage yards for the remainder of the year, and they lay their employees off, or employees come and go. In the employment arena, there's a process called Form I-9 verification, and it's always existed, but it's really blown up. As part of my practice in the last few years. And what Form I-9 requires an employer to do is to verify the identity of their employee, meaning the employee is who they say they are. And the rule for seasonal workers is if the employee is coming back every season and you both have a continuing expectation of employment, meaning the employer employee, you do not have to do a new I-9 each year, okay? If the employee you don't know if they're coming back or not, or they leave for a few years, 3 years or more, and then come back, you do have to do a new Form I-9. And it's something that I see that is very often overlooked, and most companies will never get caught. But if you are ever audited by the Department of Homeland Security, and they do this, they'll show up at your business and say, give me all of your Form I-9s, and they'll audit. If you don't follow this process, you will be fined for each employee that doesn't have a proper I-9 for each season, okay? So something to be aware of there. And then, of course, contracts. Deb and I both deal with contracts daily and in detail and in depth. Every service and you guys probably know this, but every service that you're providing should be governed by a contract. There should be a writing for it. It should explain what the services are and, avoiding liability to the extent possible. And if they're drafted properly, you can achieve that purpose. And look, I get it. I mean, I'm busy in my day-to-day practice. My clients are busy, and a lot of stuff, you get flooded in the springtime with work, and you're just taking in boats or taking in jobs, and stuff's not being put in writing. Or, I have some clients that worked without contracts or smaller operations until, we've changed that. But you have got to have contracts and everything in writing to cover yourself. If you don't, you'll get burned. So I want to stress to make sure everybody is doing that. And I have one last point before wrapping up that was part of insurance that I forgot, is the claims process. I can't tell you the amount of times where I have a client who has a claim or a lawsuit that's filed against them, and they don't submit it to insurance because they're worried about their premium's going to take a hit, or they're going to get a high claim count. And, this theory could differ by counsel, but my theory and my suggestion is that if you have a claim or a lawsuit that's filed against you, you need to turn it into your insurance agent and your insurer as soon as possible, and let them look at it and determine if it's covered or not. And if it's not covered and they close the claim up, you'll have a hit to your claim count, but it'll also show that they didn't spend any money on the matter. So it shouldn't really affect your premium. The risk I want you all to avoid is where I've had clients who have not submitted the claim to insurance because they're worried about the claim count or the premium hit. Next thing you know, they're 6 months down the road in a lawsuit. They have, a multi-$1,000 huge legal bill to the attorney. And now they realize they did something wrong and might have liability to the plaintiff, and they're facing a 6-figure exposure. And then they try to turn in their insurance company. Then the insurance company is going to say, no, this is a delayed reporting. We're not covering this claim. You're on your own. So it's important that you submit those claims timely up front, and that you have the stuff documented. And, going back to your contract, the contract will help your insurer as well to avoid some liability. So that's all I have for today to scratch the surface on some of those issues. I appreciate your time. Deb is going to do her presentation, and if there's any questions at the end, we're happy to answer any of those questions.
Thanks, John. Yeah, could you go to perfect. Sold me a lemon. So I'm probably going to talk more about nuts and bolts, traditional consumer or customer complaints, like as suggested in this slide. You sold me a lemon, or you misrepresented something to me, or you overcharged me for something. Seen the gamut of these types of complaints over the years, some involving even customer misuse or misoperation of a boat that causes damage, and then they look to a manufacturer or a dealer to even try to get a free boat or free service repair. And even on a slip and fall, I saw on a guy fell on a boat, and he sued the manufacturer and the dealer for his injury because he claimed that there was a loose bolt, so the boat was sold wrong, was manufactured wrong. So you can see some creative customer complaints, but regardless, they're just annoying. And if they escalate to litigation, they become even more annoying, obviously, and more costly. John, can we go to the next one? So I'm going to talk a little bit more today about the Michigan Consumer Protection Act. And I bring that up because if there is a traditional lawsuit on just a customer complaint like I've described, 99.9% of the time it's going to include a claim for a violation of the Michigan Consumer Protection Act. And there's going to be also many other types of claims in that lawsuit, and I'm not going to deal with those today, but I thought this was an interesting one because it appears often and it could be dangerous. It's very consumer friendly, and that's what I want everyone to be aware of and have it on their radar. Per this slide, the Consumer Protection Act is very, very broad. It covers almost everything: trade or commerce, providing service or property or goods for personal or family use. So, you know, from a consumer's perspective, they're going to be able to make that allegation on the grounds that it covers a boat manufacturer, a dealer, or even service repair. And then I guess next slide. Thanks, John. The issue with in the act is that the language is, like I said, it's broad and it's very subjective. So it allows a consumer or customer to say that there was just a probability of confusion or misunderstanding, or an implication, or even the use of the word unfair, as I put on the bottom there, is, you know, those are broad terms, and again, are subjective in the sense that a consumer can say, well, if I just misunderstood something, that's enough to let a claim survive and possibly go to trial. So I think the way that the statute is worded, it definitely is geared to protect a consumer. There also, I didn't include, if you went and you looked at the statute, and I would say, unless you're extremely bored, it's not worth it to do it. But there's like a laundry list of prohibited transactions, or transactions that are covered by the act, and they involve, you know, advertising, financing, explanation of a transaction, and they all involve these catchphrases here about causing a probability of confusion or misunderstanding. So usually you'll see a consumer in a lawsuit or trying to threaten a claim, they'll throw in at least 10 alleged violations of the act. Next slide, John, thanks. And the other issue with the act that can be troublesome to someone in the boating industry is the length of time that a customer has to bring this type of claim under the Consumer Protection Act. You basically have 6 years to bring it, which is huge. And I contrast that with, say, an auto accident. If you're in an auto accident and you want to bring a claim against the driver that you had an accident with, you only have 3 years to do it. So 6 years for a consumer protection violation is a significantly long period of time. And I think just the slide describes the type of relief. You're normally going to see a claim for declaratory relief, where the customer is just coming in asking the court to enter an order against a manufacturer or retailer or service provider, service repair provider, for, you know, misleading them and wanting to get some form of monetary relief, which in this case, the monetary relief at issue may not be ultimately significant, but the problem is the act allows the consumer to get reasonable attorney's fees. It's not a mandate. It's not a guarantee. They may seek them. The court doesn't have to. But if you're in litigation and you're defending in a claim for a violation of this act, you always have to keep the fear of attorney's fees being awarded to the consumer in the back of your mind, because litigation is, I'm sure most people understand that are on this call, is so expensive. And even if you're arguing over even like $8,000, $9,000, $10,000, you can incur attorney's fees almost in that same amount just defending the case. So you could have a claim against, or a claim brought by a customer, say even it's for $5,000, and for whatever reason, a judge or a jury awards that amount to them, you can also then have to almost double that if their attorney incurred $5,000 in attorney's fees. So what was that? Oh, sorry. All right, I thought somebody said something. No problem. So just the attorney fee provision provides a headache, an additional headache, I guess, if you will, when you're already trying to deal with one of these claims. All right, yeah, next slide, John. So I want to talk about ways to protect yourselves from consumer complaints. Within the Act, the Consumer Protection Act, there are some exemptions. Fortunately, they don't protect the boating industry based on my research. The Act does say if you're a regulated industry in Michigan, such as the banking code, even under the Motor Carrier Act or insurance code, then the Consumer Protection Act is not going to apply. And I don't think the boating regulation is as regulated. I think a claim arguably could lie. I've never litigated that issue, and I would still make that argument, but I think my research suggests that the Act could apply. There's also an exception in the Act that says, well, if you have procedures in place to ensure that customers are protected, and there is a bona fide error that results in some sort of unfairness or impropriety towards the consumer, that would save you the attorney fee risk. That would result in the customer only being awarded actual damages, and they wouldn't be able to get attorney's fees. Some defenses that are not in the Act but would be commonly used would be defense of waiver and release. And waiver, a good example of that would be if a customer comes back and makes a claim that they were overcharged for something, but yet they've already paid for the service and paid that charge, you'd be able to say, well, you waived it because you actually made the payment. There's another doctrine called the economic loss doctrine, and that basically stands for the proposition that if your relationship with the customer or consumer is based on contract, which it would be, then the only dispute you can have is based on that contract, and the consumer cannot bring any other type of claim against you other than something that's based on the contract. And going into the contract venue, John talked about this. So John, I think that's my last, yeah, actually that is my last slide. So this isn't on the slide, but the way to really protect against consumer complaints is a contract. And because you control it, you can write it up, and it's really the best method of protection possible, because you can put in your contracts with a customer that to try to shorten the amount of time that they can bring a claim. You can try to have them acknowledge and sign off they're happy with their service, they have no dispute, they understood everything. And then you can turn around and throw that in their face if they try to say they didn't understand something later on. You can also put in your contracts that customers can't bring a lawsuit if they have a complaint, that their only method or remedy would be to start an arbitration proceeding, which is sometimes more favorable than going than having to deal with a lawsuit. It's going to be probably more predictable and easier to control from a boat dealers or the boating industry perspective. And then the most important thing is that you can put in your own contract an attorney fee provision to protect yourself. You can say that if there's any claim or a lawsuit brought by a customer and you prevail, then you get paid your attorney's fees. And unlike the Consumer Protection Act that says that a borrower may get attorney's fees, you could put in your contract that you shall get attorney's fees if there's a claim brought against a customer or brought by a customer. And then my last piece of advice in terms of protection against consumer claims is document everything. I know John did say things get crazy, especially at the start of the boating season, but complaints, I have found that if a customer is up in arms and they're going to send a lot of emails that they're unhappy and they want this and they want that, those emails can be very, very helpful down the road. I had a situation where a customer was looking at my client to basically, you didn't fix my boat right, you damaged it, it's worse now. And his lawyer was going crazy, and we had emails from this customer where he admitted he had taken the boat to other marinas or other repair places. So arguably we had a very easy case of, or a defense of saying, we didn't do anything to your boat, you brought it to 2 other places, those are not us, and show those emails to the customer's lawyer. He had no idea, and the claim went away like that. So those emails are great fodder, and they definitely should be saved. And then my parting comment would be, if you ever get into a dispute with a consumer, whether it's a lawsuit or a threat of a lawsuit, you want to resolve it in writing, and because you want to guarantee that the customer doesn't come back years down the road for the same thing. And in today's world, with all the social media and the ability for customers to complain on social media platforms, you'd also want to include a non-disparagement provision in a settlement so that a customer cannot go and you know, post an unfavorable post on social media, because obviously that's not good for business. So that's my presentation. I hope it was somewhat helpful, and we're happy to answer any questions that you may have.
Thank you both very much. Does anybody have any questions? There were nothing in the chat.
We covered it so well that everybody's stumped.
You did. It was very informative. We appreciate that so much. Well, again, this is recorded, so you can rewatch, and we have both Deb and John's contact information for Maddin Hauser as well on the screen right now, too, if you wanted to write that down.
Yep, thank you everyone for their time. And I have the list here. I can circulate a quick email with Deb and my contact information. If there's any questions that come up, or certainly never hesitate to call or shoot an email.
Hey, Deb and John, it was good, straightforward stuff, so we really appreciate it. So I enjoyed it a lot.
Thank you. Appreciate it.
Yeah, thanks everybody. It was great. Have a good boating season.
Yeah.
Yes.
All right. Thank you.
Thank you.
Thanks everybody.
Bye-bye.
Bye-bye.
Everybody have a great afternoon.